Good afternoon. Welcome to the second part of the Lemkin, Genocide and the Modern World webinar organized jointly by the Jagiellonian Law Society and the Kosciuszko Foundation. My name is Marek Skulimowski. I'm the President and Executive Director of the Kosciuszko Foundation. And it's my great pleasure and honor to welcome our distinguished guest speakers and all attendees who are joining us now. Since the start of the Russian invasion of Ukraine, the Kosciuszko Foundation has been raising funds that were used to provide humanitarian assistance to Ukrainian refugees in Poland, to support Ukrainian scholars, students, and children through various educational projects. Among the foundation's key projects is also the cooperation with the Smithsonian Institution, aiming to protect Ukrainian national heritage. I'm pleased that thanks to the collaboration with the Jagiellonian Law Society, we can engage in yet another project relevant to the current situation in Ukraine. We hope today's discussion will increase knowledge about Polish Jewish lawyer Rapp Lemkin and his contribution to international human rights law. Now, it is my pleasure to introduce Dr. Elizabeth Zahenter, President of the Jagiellonian Law Society, who will moderate the discussion. Elizabeth, the floor is yours. Thank you so much.
Thank you, Marek. Good morning, good afternoon, and good evening. Allow me to extend a very warm welcome to everybody, to all of those who joined us today. We are delighted to have you across so many time zones and continents. Dzień dobry, dobry wieczór. Witamy Państwa bardzo serdecznie. It is our great honor and privilege to welcome our very distinguished faculty and our distinguished keynote speaker, Ambassador Rapp. And as Marek said, I am Elizabeth Zahenter, and I will be your moderator. This is our part 2 of our Lemkin Genocide and the Modern World webinar. And the Jagiellonian Law Society started this initiative of creating webinars dealing with Central European contribution to international law. Unfortunately, Central Europe, legal history or culture is kind of huge lacuna of knowledge among many in the West. And even though, for example, legal culture and law of nations, international law, and even human rights law goes back in Poland to late medieval, early Renaissance times, and it was incredibly progressive for the times when it was created. And I hope it is not presumptuous of me to say that this is kind of similar initiative to that of Professor Timothy Snyder of Yale, who is delivering for the public, fantastic public lectures about history of Ukraine, trying to A, close that knowledge gap, but also counteract the Russian propaganda about the existence of the Ukrainian cultures. So we have three objectives today. First of all, we will showcase Lemkin, Polish Jewish lawyer, member of the Warsaw Bar, the man who coined the term genocide, the man behind the UN Convention, and twice nominated for Nobel Prize for his humanitarian work. The second thing is we want to explain the concept of genocide. It is a peculiar crime that entered the imagination in the popular culture, but is deeply misunderstood. And we will compare it with other atrocity crimes. And we will use the example of the unjustified Russian invasion against Ukraine to showcase to you how even very obvious and egregious violation of international law, how difficult it is to prosecute them using current laws. So let me give you 1 minute introduction to law, because I know that there are some people among the audience who are not lawyers. So before Ambassador speaks, gives us keynote speech, let me just introduce you to the law. First of all, we have several major international treaties that deal with the atrocity crimes, starting from UN Charter, Geneva and Hague Conventions with many protocols, the UN Genocide Convention, the Rome Statute, and so forth and so on. And genocide is one of those very important atrocity crimes, which is defined not only in the UN Convention, but originally by Lemkin, which is a very different definition. And we also have a concept of cultural genocide, and we will also address that issue later on. And then there are crimes of aggression. For example, violation of Article 2.4 of the UN Charter constitutes a crime of aggression, which we are seeing right now. And then there are two very important crimes, categories of laws, war crimes and crimes against humanity. And there are many other laws, jus in bello and the conduct of war and crimes during occupation and so on. Let me just say one thing. Crimes against humanity laws respond differently to atrocity situations than typical war crimes, and genocide behaves yet completely differently. And the reason for it is that the crimes against humanity uniquely recognize the use of state or organizational policy to attack civilians, which makes them critical from promoting accountability of senior leaders of, directing the atrocities. And yet I would suggest to you that we are facing an impunity gap. Even though both Russia and Ukraine are parties to 4 Geneva Conventions and the additional protocol and the Hague Convention number 4 and the annex regulations, despite all of that, it is very difficult to prosecute Russia for the various crimes that are being committed. Why? First of all, genocide is a very difficult crime to prosecute because of the Stalin's revisions of the original draft of the definition of what genocide is. And also there are no mechanism to hold Russia or even Belarus accountable for the crime of aggression against Ukraine because they are not members, they are not subject to the ICC jurisdiction. Now, one word about aggression. Aggression is a leadership crime, and it is very important that we'll address and prosecute the leaders who are starting this whole war. Unfortunately, most national laws, Ukrainian law, American law, Polish law, provide personal immunity to heads of state, which basically means that lots of actions against larger leadership through the local courts are barred. And moreover, as I mentioned, ICC is precluded from dealing with the crime of aggression because of Russia's status as a non-party to the Rome Statute. So what other tribunals do we have to address those 3 major kind of atrocity crimes? Well, first of all, we have a ICJ, which is International Court of Justice based in Hague, principal organ of the United Nations. And in fact, Ukraine filed a case fairly early on before ICJ under the Genocide Convention and won, but it was a false genocide claims by the Russians that Ukraine is committing crime of genocide in the eastern part of Ukraine against the Russian subject, and they of course lost. The second court that is worth mentioning briefly for our non-lawyers audience is ICC, which is International Criminal Court. It's a much more modern court created by Rome Statute in 2002. And even though Russia is not a member, as I said, Ukraine made a declaration under Article 12 of that statute saying that it should allow ICC to have jurisdiction over war crimes and crimes against humanity committed on the territory of Ukraine. And in fact, Special Prosecutor of ICC, Karim Khan, has opened an investigation in Ukraine. And then there are special tribunals. We have a history of special tribunals, for example, constituted under auspices of UN, Special Tribunal for Rwanda, Sierra Leone, Yugoslavia, and Cambodia. And in Europe, we have a couple of courts that actually can deal with some of the crimes, even though they are really not constituted for that purpose. For example, European Court of Human Rights already addressed under the EU Convention of Human Rights certain crimes that are being committed in Russia. And then European Union has recently agreed to establish new tribunal to prosecute crime of aggression. President Ursula von der Leyen announced that while EU is supporting the jurisdiction of ICC, in light of the fact that Russia is not accepting jurisdiction of ICC, this special court called International Center for the Prosecution Crimes of Aggression against Ukraine, ICPA, will be created. And it's interesting, it will be also based in Hague and with a joint investigative team, which was established in 1922. And I want to mention to you that Poland, Lithuania, Ukraine, and the so-called Eurojust, which is the European Agency for Criminal Justice, will be members of that joint investigative team. And finally, one more word, they are also local courts when you can prosecute various war criminals for atrocity crimes using the so-called universal jurisdiction. And in fact, during part 1 of our seminars, some of our faculty describe how Poland prosecuted Nazis after the Second World War under for genocide. Sweden did the same. And actually, currently, several other countries like Germany, or Dutch courts are prosecuting, for example, Yazidi genocide using exactly those principles. And finally, it might come to surprise to many of you that US has actually patchy record in that area. You will always assume that we have a fantastic legal system, and we do for the most part. But when it comes to prosecution of atrocity crimes, well, we just have a very ancient Alien Tort Act, which was severely dealt by the Supreme Court. We have a Torture Victim Protection Act of '91, which needs amendment, but we have a one bright light. President Biden just signed January this year, Justice for Victims of War Crimes Act, which will kind of bring United States in compliance with the Geneva Convention. So this was very cursory description of the layout of land. And now let me introduce to you Ambassador Stephen Rapp. And Mr. Ambassador, it's a true honor and pleasure to have you here with us. I welcome you not only in my name, but in the name of the Jagiellonian Law Society, Kosciuszko Foundation, American Bar Association, and all the wonderful organizations and universities that are co-sponsoring this event. And while Mr. Ambassador needs no introduction, let me just tell you a few things, the key points of his amazing career. Mr. Ambassador served as a fourth U.S. Ambassador at large for global criminal justice from 2009 to 2015. He was appointed by President Obama. And as an ambassador at large, he was responsible for heading up Office of Global Criminal Justice in the U.S. Department of State. And in this position, he was advising Secretary of State on issues related to war crimes, crimes against humanity, genocide, and American policy related to prevention and responding and securing accountability for mass atrocities. He also coordinated American support for international criminal tribunals, including ICC. And he's widely credited with arranging for the UN Commission for Inquiry to gain access to the documents documenting torture by the Assad regime. In addition, from 2007 to 2009, Ambassador Rapp was a prosecutor at the Special Court of Sierra Leone, and he succeeded in the historic prosecution of the former Liberian President Charles Taylor for war crimes in Sierra Leone. And it was first conviction, as far as I know, in history on crimes against humanity and charges for sexual slavery, forced marriage, attack on peacekeepers and child soldiers in violation of international law. In addition, from 2001 to 2007, he was one of the chief of prosecution at the International Criminal Tribunal for Rwanda, where again, his team achieved first conviction in history for the mass media, against leaders of the mass media for the crime of public incitement to commit genocide. And even when Ambassador Rapp was the United States Attorney in the Northern District of Iowa, he actually won historic convictions using Violence Against Women Act. And more recently, Mr. Ambassador has been serving in various advisory capacities to various institutions, among them the Blavatnik School of Government at Oxford, special advisory capacity to the Center of Prevention of Genocide, Distinguished Fellow at the Hague Institute of Global Justice, and as Distinguished Fellow for the Prevention of Genocide in the U.S. Holocaust Memorial Museum. So with that, Mr. Ambassador, the floor is yours.
Okay, well, thank you very much, Elizabeth, for that introduction, and also of myself, but also the introduction to the field of international criminal law and what we're facing in Ukraine. I've been often in Poland recently, but haven't spent as much time as I should. I'm hoping to be in Warsaw perhaps later this month, and I look forward to meeting people in person there, some of whom are on the panel today. I was most recently in Krakow and on the train through Przemysl to Lviv the weekend before last for the conference on justice in Ukraine, which was, I think, a fantastic conference in terms of bringing experts together to discuss how we can achieve accountability for these massive crimes. We have, as everyone knows, a war in Europe like we have not seen for now 78 years. We have strong evidence of the large-scale commission of international crimes, overwhelmingly on the Russian side. As you went through that list, of course, we have war crimes, we have crimes against humanity, and knowing our subject is genocide and the pioneering work of Raphael Lemkin, we also have allegations of genocide in that certain conduct by Russian forces and by the Russian government fall within the defined acts set out in the Genocide Convention, which will be 75 years old come December 10th or December 9th this year, the day before the 75th anniversary of the Universal Declaration of Human Rights, quite a week of anniversaries. The challenge on genocide, which I'll discuss more deeply later, is the high bar that courts have set as to genocidal intent, as to physical and biological destruction of a substantial part of a population. Of course, we also have the crime of aggression, the overarching crime the judges in Nuremberg said is the one that contains within it the accumulated evil of the whole. As we watch these crimes being committed before our eyes, we have to recognize that they've been committed with the expectation of impunity on the Russian side, and we shouldn't minimize the failure of accountability, the world's failure of accountability for the mass atrocities in Syria, the role that played in reinforcing that Russian expectation. Despite the horrors in Ukraine to date, Syria does remain, because of the numbers of death and their brutality, certainly north of 500,000 dead, the worst atrocity crime scene of the 21st century. 90% of the crimes committed on the regime side, though certainly significant, and even genocidal crimes committed on the side of the jihadists, particularly by ISIS. But of course, as far as the regime is concerned, Russians have been quite complicit in helping the Assads develop their machinery of disappearance, detention, torture, and murder, where the dead probably exceed now more than 100,000 individuals, largely civilian opponents of the regime that were hoping that Syria could become a normal country, a democratic country, and that was a threat that Assad and his Russian allies could not abide. But we also have the direct intervention of Russian forces under Putin's control since 2015, and their participation directly in the targeting of hospitals and medical personnel and humanitarian actors, violating the oldest norm in international humanitarian law that comes to us from the first Geneva Convention of the 1860s. And also their flying in support of Syrian aircraft that was dropping chemical weapons, another norm that's been with us for more than a century and almost universally observed, used because it could make neighbors with rebel presence uninhabitable for civilians, because it would kill them when they sought refuge underground, where ballistics could not easily reach them, but heavier than air gases could. And of course, in the context of Syria, we've had no ICC jurisdiction. That was attempted with a resolution in the Security Council. 13 countries of the 15 voted yes. Russia, China voted no. Those were vetoes, so it didn't happen. No possibility, of course, of the territorial state that's committing 90% of the crimes to prosecute itself, or agreeing to a hybrid court to do so in partnership with it. On the positive side, we've seen the dramatic increase in the quality and quantity of documentation of the crimes by civil society organizations. And that includes not just the crimes, but also the linkage evidence that's so necessary to connect those crimes to the high-level individuals who are responsible. And we've also seen the historic creation of an investigative mechanism by the General Assembly that consolidates that information from civil society organizations and other actors. The widespread growth of acceptance of universal jurisdiction in third countries, and many of those countries gaining greater resources, also cooperating together and forming joint investigative teams to do a more strategic job of using the jurisdiction that they have available. And that's led to some successful prosecutions of regime perpetrators, the third of which occurred in Berlin in late February, which is really remarkable in the sense that mostly universal jurisdiction has been used to prosecute people almost a generation after the crimes were committed. These are being prosecuted while the crimes are still committed in Syria. Now, when we deal with Ukraine, we are in a quite different place. Still gaps, as Elizabeth indicated, but we do have judicial systems that have the jurisdiction, that have the legal right, have the legitimacy to prosecute many, but not necessarily all, of the crimes that have been committed. We have, of course, the International Criminal Court, and we have to absolutely make it clear that the International Criminal Court has territorial jurisdiction by reasons of the declarations that Elizabeth mentioned. I was twice to Kyiv as ambassador in 2014 and 2015 to encourage the government then to make particularly that second declaration that gives the ICC total jurisdiction to the extent that they're grave crimes and meet the ICC threshold of war crimes, crimes against humanity, and genocide committed on the territory of Ukraine. And I want to make it absolutely clear, because there's been debate on the issue, and unfortunately the US government hasn't been clear on this, as clear as it needs to be, but I hope that'll be clarified in the next few days. That's territorial jurisdiction, and it applies to the nationals of third states that aren't in the ICC. It's like if I come to Warsaw and I murder somebody, it's up to the Polish authorities to determine where I'm going to be prosecuted. And if you go to Ukraine and you murder somebody, it's up to Ukrainian authorities to decide where you're going to be prosecuted. And they've decided that if a crime of a particular threshold, it should be the ICC, and that is their call. So it has jurisdiction of those three crimes, but not of genocide, as Elizabeth has said. We also have a very active Prosecutor General's office with a great deal of international assistance being provided. Police agencies, the National Police, the Security Police, the SBU, that are investigating these crimes, and they have jurisdiction for war crimes, but not for crimes against humanity. That's not in their statute. They do have jurisdiction for genocide, and they do have a jurisdiction under an older statute for the crime of aggression. On the other hand, they are limited to not being under international law. They cannot prosecute the leadership of the Russian state, particularly the Troika. And by Troika, I mean President Putin, the Prime Minister, whoever that is, and the Foreign Secretary, Lavrov, can't be prosecuted while they're in office by another state. They can only be prosecuted by Russia if it were to do it unto itself, or by an international court. And of course, the ICC is such an international court. And so for the crimes that are before the ICC, war crimes, crimes against humanity, and genocide, that court can, and I suspect will soon, prosecute Putin for war crimes and crimes against humanity, and has the right to do so under Article 27 of its statute, and by a variety of international decisions, particularly its decision in the Jordan case involving Sudan in 2019. It makes no difference whether Russia has waived that right or not. It is a court that's been called into being by the international community as a whole. We also, of course, have a great deal of activity in third countries, actually the formation of two JITs, following joint investigative teams, following on the heels of the most famous JIT yet, which was the JIT with the Dutch and the Belgians and the Australians and the Malaysians and Ukraine that built the case that was prosecuted in absentia at Schiphol Airport courthouse. There's one there in the airport that prosecuted those responsible for the shooting down of MH17 over Ukrainian territory in 2014. But we now have JITs that are working on developing cases in European countries, and Attorney General Merrick Garland was with us in Lviv, which was also, I should note, in the past, Poland, Lwów, and before that is Austria, Lemberg, the hometown and the place where Lemkin was educated and taught. But the U.S. has joined as well in that joint investigative effort for those third country prosecutions. Now, just to talk about a moment, and I want to focus, and I don't want to take all the time here for my remarks, but on the different crimes and what's really necessary to succeed on them, and the challenges that are faced in different court systems. First of all, of course, we have war crimes, and as I indicated, certainly enormous evidence of massive war crimes committed. I tend to view war crimes in conflict in sort of two forms. One are the more individual acts of the kind of which we see evidence in Bucha, the acts of shooting civilians down in the street, of putting people into squalid detention places where they're tortured, electrocuted, sexually violated, sometimes murdered, and those kinds of crimes those kind of acts are without doubt war crimes. The challenge with those crimes is attributing them to the high-level actors. The ICC, as the Yugoslavia Tribunal and other tribunals where I prosecuted, has the benefit of international law that allows you to attribute responsibility up the chain of command if you can show that the people doing those crimes had, were under the effective control of that leadership. and those leaders, those military commanders, but civilian leaders all the way up to Putin, had knowledge or should have known or had reason to know. The standards are a little different, but of that conduct that was being committed, and then failed to take action to prevent or punish. Actually, I think at the ICC, the statute is, I think, pretty clear in this regard with some of these acts, because despite the overwhelming evidence of what happened that's been broadcast and documented by journalists from around the world, the Russians have totally denied it, haven't done what many countries would do, which is to say, well, we'll deal with this, we'll prosecute out of control soldiers. There's always a few bad apples. That's usually what countries say. They haven't said that. In fact, they've honored the units that have committed these crimes. And so I think actually we have a relatively strong case of command responsibility. However, under the laws of Ukraine, which of course also has jurisdiction over everybody up to those top guys, they don't have command responsibility in their law. So they have to show more direct involvement in terms of ordering it or contributing with intent to these crimes. But there's a second kind of war crimes that are being committed, and those are those that appear to be part of the strategy of the Russian forces. Now, of course, you could say perhaps even this intimidation and terror of the civilian population through this killing could be part of that strategy. And if you can find those papers and develop it, that would make for a very strong case. And sometimes you do have, particularly among groups like ISIS, et cetera, horrible things that are done as part of strategy, like the destruction of them and the sexual slavery of the Yazidis, who were viewed as infidels. They deserved it. But here that's more challenging. But from a top-down level, there's no question that the bombardment that's been carried on by Russian airplanes, by Russian sea-launched missiles, by Russian artillery, has had a tremendous effect upon the civilian infrastructure. I should note, however, that when you deal with bombing and bombardment, and Tom and others can talk about this, it's very challenging to prove that these are war crimes, because it is a war crime to intentionally attack civilians. On the other hand, you can attack civilian objects if they're being used for military purposes. You can even attack them knowing that there may be civilian loss of life, but because of the large-scale military advantage that can be gained. And you always have to look at it from the perspective of the attacker, and you hardly ever have the attacker's orders as they do these things. On the other hand, indiscriminate attacks, like the kind we've had in Mariupol, where they seem to be carpet bombing the city, or using what, from Putin's origin is when he first led the Russian state, Grozny rules, the sort of flattening of the capital of the sub-republic of Chechnya within the Russian Federation, that kind of disproportion, that kind of indiscriminate, in which they make no distinction between civilian and military targets and just destroy everything. That is a crime, and certainly we see that in Mariupol. On the other hand, Mariupol is still under the control of Russian authorities, so actually proving it, not impossible, is more challenging. On the other hand, what we've seen with the attack on civilian energy infrastructure that began in an enormous way since October 10th, and seems so clearly focused on freezing and starving the people of Ukraine and terrorizing them into submission, and has been so widespread and so massive, one could infer intent to attack and intimidate civilians. But the international law does give one also this, it's challenging to use this idea of proportionality. And the effect, even though it can be said civilian military or energy infrastructure can be hit as a military target and can be something that benefits the armies in the field and the resupply of those armies. The benefit of this attack on civilian infrastructure was so minimal in terms of what was happening in Bakhmut or what was happening in Kherson or other places where the war is actually being fought on one side, and so massive in terms of its effect and threat against the civilian population that it was disproportionate, and as such is a war crime. Now, there's not been success in the past on that kind of proportionality analysis, but this is one where I think the case is very strong. And if we were to see out of the ICC, as has been reported there may be applications in front of the pretrial chamber. If we see charges against Putin in the near future, I would think it would be on that basis. Let me go on just to mention crimes against humanity for a moment. And of course, as Elizabeth said, these are part of organizational plan or policy. Certainly, if you were attacking civilian infrastructure on a massive way in order to starve and freeze the civilian population, that would be a plan that would be sufficiently widespread or systematic and be part of an attack on the civilian population, and of course include extermination as part of its intention. That could be a crime against humanity as well, and so could be charged as such. And significantly, the United States, in a statement by Vice President Kamala Harris at the Munich Security Conference last month, made the declaration from the State Department that the United States has found, based upon evidence, that Russian forces are committing crimes against humanity. Let me deal now with the genocide and this crime that many call the crime of crimes, and it's a crime that I successfully prosecuted at the Rwanda Tribunal. And I understand the Rwanda Tribunal almost stands alone in being successful in achieving genocide convictions. The exception was the Yugoslavia Tribunal that succeeded with the mass killing of Muslim men and boys at Srebrenica, the murder of 8,000 in July of 1995. But all of its efforts to deal with what was so clearly crimes by Bosnian Serb forces with the support of Serb authorities to destroy or to wipe out or to displace the Bosnian Muslim and sometimes the Bosnian Croat population, the courts would not find that was sufficiently genocidal, that killing some people in order to get others to move isn't genocide. And so, and of course, we've had litigation still pending in the International Court of Justice on the case of Myanmar, where actions by the authorities in Myanmar, particularly the military, against killing maybe 10,000 civilians and driving 800,000 over the border into squalid camps. And there wasn't even a certain expectation that they would even have camps to go to in particularly August and September of 2017 is allegedly a genocide. That case is before the ICC, not on genocide, but because of forced deportation into Bangladesh as a crime against humanity. But it is challenging to prove genocide. And of course, that's in large part because Raphael Lemkin did not fully succeed in his vision for a genocide convention. And he'd seen genocide as being committed in three different ways. Physical destruction of the kind that we had in the Holocaust and in the Rwanda context. 100,000 Tutsis murdered because they were Tutsis in Rwanda, 70% of the population of Tutsis in 100 days in 94, the crime that I dealt with, which is so clearly based upon the destruction, the physical murder of that group, though it also included rape and other horrible things done to people that didn't involve death. And one doesn't have to prove death in order to, or murder, in order to have physical destruction, acts of rape that just can destroy the community as well over time. And that as a serious injury can also be part of the actus reus of genocide. It also includes biological destruction as actus reus, which include forcible sterilizations and limitations of births by a group. And obviously that might be done in a way in which nobody was killed, but over the course of a couple of generations could effectively wipe out a group biologically. And of course, that's what's been alleged in Xinjiang in northwest China against the Muslim population there, particularly the Uyghurs, and efforts to control their births and to some extent to force people into marriages outside their ethnicity and religion, and creating a situation where indeed, if this is carried forth over 2 or 3 generations, that group could cease to exist. It's a biological destruction. The idea of cultural destruction, an attempt by an occupying power, for instance, to wipe out an identity, wipe out a religion, Russify everyone, for instance, Germanize the population or whatever. And Poland, having been partitioned and in the past, has experienced conduct like this against the Polish nation. In which potentially people would not die, but they would be forced to become something else, forced to speak a different language, forced to follow different customs, forced to go to a different church, or not to go into a church at all. That's another way in which you destroy a people, and that particular effort was not successful in the negotiations in New York that preceded the genocide. The promulgation of the Genocide Convention on December 9th, 1948, and it being sent forth for ratifications around the world. One interesting aspect of this, and I owe it to my friend Payam Akavan, the Canadian lawyer who was speaking in Lviv 9 days ago, he discussed something about the history and one success that happened that did in a way really has to be looked at as perhaps something that really does open the door to cultural genocide. And that was when the treaty was almost completed, they had eliminated cultural genocide, and they had eliminated a proposed section on transfer of children from the one group to another. And in fact, it was the Greek delegation that had just experienced the Greek Civil War, which was a war largely fought on ideological basis, a communist group that attempted to take control of Greece that was defeated and generally withdrew into Bulgaria and elsewhere. And Greek children were in fact kidnapped and taken into Bulgaria and into the Balkans and raised there. And the Greeks insisted that this provision be included in the Genocide Convention. And so we now have that in the convention, and of course, in what the Russians have done, as you know, obviously the Prosecutor General said we've had the transfer of some 16,000 children. We've had the Russians acknowledge it, praise the work of the woman who's heading it, Maria Lvova-Belova. We've had Putin himself issue a decree which facilitated adoptions of these children into Russian families. In the West, in Canada, the US, and elsewhere in Australia, there's been a recognition that things like residential schools where children are torn away because their culture is not approved of in say, the indigenous reservations areas and taken to residential schools, even with so-called good intent, has led Canadians to view that as genocide. Of course, those children were allowed to go home in the end. These children, in fact, will have been separated permanently and gained new families. And so there's no question that what the Russians are alleged to have done, I mean, the Prosecutor General says 16,000, a Yale report with data up till 6 months ago said 6,000. And certainly we have a number of individual cases and witnesses, and some 307 that managed to get out. We know a fair amount about this crime. This certainly is a war crime. It is a war crime in the sense that it is never legal. I mean, the Russian can say, oh, we wanted to get them out of the war zone. The Geneva Conventions and its additional protocol, including one additional protocol 1 that the Russians signed, said, thou shalt not move children from an occupied area to the warring party's state, even for reasons of security. You can do it for reasons of health temporarily, but then only with the permission or attempt to gain consent of the family. And the ICC statute said an unlawful deportation is a crime. And the Geneva Convention makes it unlawful, and the Rome Statute makes it a crime. It's a pretty solid war crime. And it's one I think that we'll see charges on very, very soon. It's also a crime against humanity, this forcible deportation. Is it a genocidal act? Yes, it is. The question is it part of genocide? And of course, there's two aspects of every crime. One is the physical element, the actus reus, so-called. The other is the intent element. And did the Russians intend to doing this, to destroy the Ukrainian nationality in whole or significant part? And obviously you can say, well, 16,000 even, given 40 million Ukrainians, may not be viewed as sufficiently significant. But on the other hand, we have in Srebrenica genocide with 8,000 killed in a particular area. So it is something that's close to the threshold. Now, I don't want to, there's also indication of other acts that are being done and other propaganda, for instance. The Ukrainians actually have an open in absentia case against propagandists that have essentially put out all this vile Ukrainian, anti-Ukraine nation doesn't, we've heard some of it from Putin, but some of this is really outrageous. And, the only good Ukrainian is a dead one almost in the terms of some of these propagandists. And there's certainly the chance that we have, even if we don't have genocide, we may have incitement to genocide, because you don't actually have to prove a genocide was committed. You only have to prove that there was an intent. And you were in a situation where there was widespread violence and threat, et cetera, and the real potential of a genocide. And of course, that's the conviction that my team won at the Rwanda Tribunal against RTLM Radio. We didn't have to prove that it caused the genocide. Frankly, it did in a lot of places. We just had to prove that there was an intent through those broadcasts to do it. And we were able to look at the effects and everything else and all of the context of the broadcast in order to prove that intent. I will finally just say something about the crime of aggression, the ICC can't do it. Specifically, the ICC statute said it does not apply to the nationals of countries that have not ratified the Rome Statute and the aggression amendments. To prosecute it would take a special tribunal. I'm one who believes that it would be possible for the UN General Assembly to authorize the Secretary General of the UN to negotiate with Ukraine the establishment of an international tribunal. And to a large extent, that was done with Sierra Leone, the court where I was a prosecutor. Now, admittedly, the recommendation there came from the Security Council, but it wasn't a Chapter 7 resolution. It was a recommendation, and the General Assembly can similarly make the recommendation, and did in the case of the establishment of the Khmer Rouge Cambodia Tribunal. So there's precedent for that. And if that court were then established on that wide basis by a vote using so-called uniting for peace principle and precedent, which have been used so far in these resolutions that have passed by votes of around 141 to 5 or 6 or 7 by the General Assembly, if we had a vote that was at least 2/3 of those voting yes versus those voting no, that could be the basis upon which one would establish a court. Of course, it would be a leadership crime. You'd only be charging leadership of Russia, potentially also leadership of Belarus, whose territory has been used to facilitate the invasion. And of course, with all of these situations, it'll be difficult to get the perpetrators into custody. Why is it important to do that? I think we only have to think back to 24 February last year and what really outraged the world. We've had horrible things happen in a lot of places during the post-World War II period, but outraged the world was here as a people going about their business, going to work, going to school, slowly but surely developing into a functioning democracy. And because that democracy was a threat to Putin, not NATO, not military force, not an attack, suddenly death starts raining from the sky. And the whole nation is then called into the defense of hearth and home. And all sorts of people have seen their property and their lives destroyed. War crimes are about, crimes generally against civilians or people that have surrendered. Crimes against humanity are all about civilians. But genocide is about destroying a civilian population. But what of the young men called to the front who were bleeding and dying? They wouldn't be at the front. They'd be in school. They'd be at work were it not for this crime. What of the homes, the dreams, the businesses, everything else in this country? All of that destruction. Why? Because of Putin's decision. And all of those results, all of those damages, all of that destruction, all of that death is because of the crime of aggression. Some of it because of war crimes. Some of it's crimes against humanity, but all of it's aggression. And so the need to reinforce that norm, there have been other situations in the world that maybe there should have been a prosecution for aggression on. But what we have here is something like we had on the Polish border, September 1st, 1939. And that resulted in the conviction of the Russian leadership the conviction with Russian cooperation and participation, and with the participation of the Allies in the war, the so-called United Nations at that time, which included Poland, to try those individuals for that crime against peace, the crime of aggression of the Nazi leadership. And this is the same kind of thing. And if we don't enforce the norm in this situation, whenever else would we do it? So I think that's the reason to take that step. We'll see. The challenge I think the Ukraine faces, it's evident that there's willingness in the General Assembly to denounce the Russian aggression, the willingness of countries, particularly from the global South, that have maintained their neutrality at this stage to support a resolution in this case, the sort of argument that there's other situations like Britain and in America, in Iraq in 2003 that should have been prosecuted, and this is double standards. There's a lot of arguments on why this may not get the support that's needed, and I'm one who thinks it really needs to be done on a global basis in order to not have problems with head of state immunity. But in any case, that's something that people will talk about a great deal, and we'll see if it happens. But meanwhile, we do have the prospect of cases being built at the ICC against very senior leaders of Russia, and we have continued efforts at the Ukrainian level and in third countries to prosecute other perpetrators for the involvement in the three international crimes of war crimes, crimes against humanity, and genocide. So thank you very much. I'm sorry I've gone on as long as I've had, but I wanted to cover what's happening over a front of 2,000 kilometers over the last year, and underlie the importance of achieving accountability for it, because impunity does breed impunity, and if these crimes are not punished, we can only look forward to them being committed in other places of the world, and to none of us being safe in our homes, in our communities in the future. So thank you very much.
Thank you, Mr. Ambassador, for this amazingly thorough and informed presentation. We will now allow the audience and our speakers to ask questions of Mr. Ambassador. And allow me to ask the first question, actually. Mr. Ambassador, what do you think? Should United States pursue special tribunal? Like there was some talk about it, and there are several scholars from Georgetown and many others who are, advocating for creating this special tribunal. Do we still need it in light of the European initiative of creating this special tribunal for the crime of aggression, or do you feel that we should still proceed with this special tribunals by United States, leaving the...
Well, I mean, obviously, I think the United States should join with Europe and with other countries. There is now a core group that's supporting the creation of a tribunal. The only global South country in it to date, interestingly, is Guatemala. But generally, it's going to be necessary to build more countries into this sort of core group. And the importance of that is to get a vote of the General Assembly. Now, it is possible for Europe to proceed through the European Union, of course, the European Union following the rule of, of unanimity, and there may be countries of the 27 that don't support it, but there's also the possibility of establishing it under the auspices of the Council of Europe, which, of course, is a much broader constellation of countries, including even Turkey. And including Russia until last September. And so that also could be an alternative. On the other hand, a more narrowly based court raises the question of, well, what's to keep the Russians from establishing court with Belarus and Iran and Cuba and Syria, et cetera, and creating phony trials against Zelensky or something. I mean, obviously there wouldn't be any legitimacy to that, but you want to do it on the broadest basis possible. Now, I think the United States in Lviv, my successor as ambassador at large, Beth Von Scott, was present, and she read out a statement which was favorable to the concept, but still raised questions about the U.S. position and where the U.S. will land on this. I tend to think eventually on the right side. You know, you have countries like Britain that weren't very strong for it initially, and now have become key members of the core group. And so I think that number will build. It might be, from a political standpoint, that if the ICC proceeds with high-level cases against Putin on war crimes, many will say, I remember the Germans, when they weren't supporting this in March, saying to me, this was in May, from their legal advisor, he said, well, why do we need it? The ICC can get to the war crimes, charge some of the same people. Shouldn't we put all our eggs in one basket? And certainly that's been the pitch of the prosecutor. And so, in America, we prosecuted Al Capone for you know, tax evasion, not mass killings, and we got him, you know, et cetera. So who needs to get the crime exactly right? So there is that kind of argument. I don't know. We shall see. On the other hand, international structure is an edifice, and it's built through these successful cases. And if you don't enforce the norm here, when will you ever do it? So I think there's a reason to do it. Understand it doesn't have to be a big court. The case isn't very complicated. I sat in the People's Tribunal last week or 2 weeks ago in The Hague with a South African and Indian judge, in which we heard a prosecution team present 16 witnesses, 12 live witnesses from Ukraine, experts like General Wesley Clark and others, and confirmed an indictment. It's not as complicated as the war crimes issue. And of course, it may not need judges for quite a while because it'd be challenging getting these leaders in custody. So, I think it's worth doing. But it at the moment really lies in the question of whether countries in the global South who view the world as having taken too much attention to Ukraine and not enough to them get on board, because their own sovereignty, their own borders, are important to them, and they can see the principle here, and this establishing a precedent that could benefit them in the future.
Thank you, Mr. Ambassador. If any of our speakers would like to ask a question, so please unmute yourself and do so. If not, then you know, you will have a chance later on. But if not, let us proceed with the presentations. Then thank you again, Mr. Ambassador. We truly honor you for everything you have done for humanity. I'm speaking from my heart. Now let me introduce to you the order of the presentations. We will now move a little bit to Lemkin. We will have Professor Agnieszka Bieńczyk-Missala, who will talk about Lemkin and his Polish chapter. After that, Professor Dirk will talk about Access Rules, seminal book by Lemkin. And then we will move to Professor Vrdoljak, who will deal with cultural genocide. And after that, we will move to prosecutors, Prosecutor Thomas Hannis, who will tell us what are the lessons learned for the special tribunals, and Nick Yurlov, Ukrainian attorney, who will tell us the Ukrainian perspective. So with that, let me introduce to you Professor Agnieszka Bieńczyk-Missala. She is a full professor of political science at the Warsaw University. She was vice director of the academic research and international cooperation at the Institute of International Relationship at the University of Warsaw, chair of the prevention of human rights violations funded by the National Science Center. Among others, she was the holder of the Jan Karski Educational Foundation Scholarship at the Georgetown Leadership Seminar in 2016. And the floor is yours, Agnieszka. Go ahead. Unmute yourself, please, and you can share your slides.
Thank you very much. I have prepared the presentation. Thank you very much for having me. It's a huge privilege for me to participate in this panel. And it's also a privilege for me to speak about Rafał Lemkin, because he is really my personal hero. He inspired me a lot when I'm thinking about my research and my life. And I'm not going to talk too much about his concept of genocide, because I know that my colleagues will do it even better. But what is important to know that Rafał Lemkin, he was completely forgotten in Poland, in communist Poland. Polish science was in a kind of isolation. The Soviet Union, communist authorities in Poland didn't appreciate the concept of genocide and his achievements. So I personally discovered Rafał Lemkin during my study time when I became interested in genocide questions, and I was shocked that nobody so far had told me about his life and his achievements. So Rafał Lemkin, he was born in a Polish Jewish family. It was quite assimilated family. 3 languages were spoken there: Polish, Russian, and Jewish. And it was the time when Poland was under the partition. So he was born on the territory of, let's say, Russian Empire. And Poland regained independence in 1918. What was interesting that his family, it was a farmer, the family of farmers, and on the territory like near Bezwodne, Wołkowysk, there was very like rich, it was a multicultural territory inhabited by different ethnic religious groups. So for sure it influenced Rafał Lemkin. When we talk about his education, the most important for him was his study time in Lviv. He studied law at the Faculty of Law and Political Science. It was Jan Kazimierz University at the time, and he obtained also a PhD in law in Lviv. It is important to know that at that time, at the university in Lviv, it was like the best faculty of law. A lot of renowned scholars, lawyers provided the courses, and especially he participated in Professor Juliusz Makarewicz seminars. He was a renowned expert in criminal law. And probably you know Stanisław Rappaport, Hersch Lauterpacht. Lauterpacht also contributed a lot to the concept of crimes against humanity, but also the concept of human rights during the Second World War and after that. Then he moved from Lviv to Warsaw. And now let me tell you a few words about his inspirations, why Rafał Lemkin decided to deal with the question of mass killings. In his autobiography, he writes about the famous book Quo Vadis, which is a masterpiece of the Polish literature by Henryk Sienkiewicz, and it was and his mother, when he was at the age of 11, his mother read him about suffering of Christians in Roman Empire, and Rafał Lemkin started asking questions. Why nobody helped Christians at the time? Where was the police? Where was the law? And she said, I don't have the answer for you. You have to think more. You have to find an answer. Then, of course, when he was a child, there were a wave of pogroms of Jews around Wołkowysk. So he, of course, was aware of anti-Semitism, and it had an impact on him. And then the question of Armenian genocide. When he was a student, there was a famous discussion, which he wrote about it in his autobiography. He started asking questions. Why international community didn't react to Armenian genocide, to Armenian massacres. And his professor answered, you know, when there is a farmer and he has some kitchens, one day he decides to kill those kitchens and other farmers don't interfere. So it perfectly showed what was the perception of the question of sovereignty in the world. Rafał Lemkin was shocked, and he just answered, you know, people were not chickens. So, you know, it was something what inspired him in the future. When he was in Warsaw, he was very successful. He also studied, participated in different projects, translation projects, etc. When we talk about criminal law codes of totalitarian states, especially fascist Italy and the Soviet Union, it was something natural for him that he somehow decided to devote his life to criminal law. In Warsaw, he was a lawyer, a jurist, a prosecutor, advocate in the end, a lecturer, and he very often presented Poland in numerous international conferences. So it was important that he knew really like the best Polish lawyers, but also he was like recognized. He had this chance to meet international lawyers. And because at that time, mass killings were not forbidden in international law, he prepared the paper for the conference in Madrid with the proposal to outlaw barbarism and vandalism. Barbarism, more or less, he understood as genocide, and vandalism as a destruction of the property, some goods. But to be honest, he was not understood. And finally, he decided to start his private practice in Warsaw. And then the war broke out. So in September 1939, when Poland was attacked by Germany, he decided to leave Poland. At the very beginning, he wanted to participate fighters, but his train was bombed. Then he moved to Volkovysk, to his family. And because he was aware of Nazi ideology and he expected future massacres, he asked his family to escape with him, but nobody believed him, and his parents didn't believe him. So alone, he decided to go to Vilnius, to Riga, to Stockholm. And he was very smart. He spoke like between 7, 11 languages. And in Sweden, after 3 months, he started providing lectures in Swedish. And at the same time, he asked the government of Sweden to help him to gather materials about German law and practice in occupied Europe. So when he moved to the United States, he was enrolled to Duke University. He was able to provide lectures about comparative law and Roman law. But at the same time, he had a lot of materials about German occupation, and it was possible for him to write this breakthrough book, Axis Rule in Occupied Europe, which was published in November 1944. And for the first time, he used this word genocide and his concept genocide, which he provided in his famous chapter number 9. Then, of course, he was, to be honest, this concept was by some lawyers criticized, by some lawyers like accepted. He started to provide lectures about the concept, to write articles, and finally he was able to become an advisor to the U.S. administration, and especially to Judge Robert Jackson, which and he was able to observe also criminal proceedings in Nuremberg. But when he was in Europe, he traveled to Europe in 1945, 1946. He not only observed trials at the Nuremberg Tribunal, but also he convinced himself that Europe completely was changed in terms of ethnicity, in terms of ethnic structure, and he was shocked and depressed because he found out that around 49 members of his family was killed, also his parents. He met some survivors in some camps, And he was just, you know, depressed. He was disappointed with Nuremberg processes because the crime of genocide was not included in final judgments, and also crime against humanity was like covered only, the concept covered only the time of war. And Lemkin was aware that also before war, huge crimes were committed, of course. So he was repeatedly hospitalized because of the hurt and because of the pressure, blood pressure. But one day when he was in the hospital, he could hear on the radio that in New York, there would be the first session of the UN General Assembly. And so he decided to check him out from the hospital and to go to New York. And he started his crusade, as he called that, for the genocide. So several steps were important. Of course, the resolution 1946, the General Assembly called for genocide to be recognized in a national law, in the universal jurisdiction. Then he proposed, he was the most important author behind the draft of the Convention on the Prevention and Punishment of the Crime of Genocide, which was adopted in December 1948. But for him, it was not the end of his efforts. He wanted to see that the convention entered into force. He needed 20 ratifications, and he devoted everything to achieve that. He was personally involved. He, like every day, I met one day in Jerusalem, I met a woman who was a journalist in New York at the time. And she said that every day she could see Rafał Lemkin waiting at the door, you know, trying to talk with diplomats about ratification, about his concept of genocide and ratification of the convention. He used to write personal letters to diplomats, representatives of governments, with this request to ratify the convention. So finally, when the convention entered into force, he said that it was like the best day in his life. He was thinking about his mother at that time, and she sacrificed a lot, like his health, his job, and then he lived in a very modest conditions. Then he died in 1959 in New York. Not so many people participated his funeral. So what is Lemkin's legacy? Just to summarize his achievements and his life, like in my opinion, of course, he contributed a lot to international law. He coined this word genocide, the whole concept. He proposed the concept. He wrote the draft of the convention. He also is a great example of personal activism. He's a great example for, he used to say about himself that he was an unofficial man. So he showed how to push some ideas. He was like a very sensitive person with, he was able somehow to put link between morality and international life and international law. He contributed a lot to changing of our understanding of sovereignty, which today we also understand when we talk about responsibility to protect concept. And he had a great respect for law, for institutions. In his book, he proposed to establish International Criminal Court. He proposed to have efforts to prevent future crimes. And what is also important, that his concept was universal. So he didn't refer only to Holocaust, but he was also the first who said that Holodomor in Ukraine, that it was a genocide. He was interested in colonial powers crimes, saying that there were these genocidal factors as well. So for sure, he contributed a lot to international law and our understanding of crimes and our action in the context of life, so crimes. So I hope that also taking into account the situation in Ukraine, that somehow we will be inspired and we will use this opportunity to fight with impunity. Thank you very much.
Thank you, Agnieszka, for this amazing presentation. You have brought Lemkin to life. Like we can feel we know the person too, which is very important, not just his legal legacy. So I'm going to hold the questions till the end of all the presentations, if I may. We have several questions already, and I will introduce to you Professor Moses now. He is Anne and Bernard Spitzer Professor of Political Science at CUNY College of Law. And he was raised in Brisbane in Australia, attended the University of Queensland, but his PhD is from UC Berkeley, California in 2000. He had many faculty positions, including Distinguished Professor of Global Human Rights at the University of North Carolina, Chapel Hill, and several others. And his first books on the German intellectuals and the Nazis was awarded Historical Book of the Year Prize. He has written many other books since, his most recent ones in the problem of genocide, permanent security, and the language of transgression, which came out in 2021. He's on the Journal of many genocide studies and genocide research, and a specialist of the whole area of the genocide law. So Professor Moses, the floor is yours.
Thank you very much for the invitation, for the generous introduction. It's an honor to be here. I hasten to add that unlike some of the other participants, I'm not an international lawyer, although I did study law in Australia for a few years. I'm really an intellectual historian and someone who works in the political history of ideas. And I now teach international relations at the City College of New York. I am the senior editor of the Journal of Genocide Research, and there I've, with one of the other editors, a Moldovan colleague, an historian of the Holocaust, Diana Dumitru, have initiated a forum on the Russian invasion of Ukraine. So if you look at the website of the journal, you'll see a number of these contributions, and several more by Ukrainian scholars will be published in the next few months, including one by Yulia Yoffa on the case of the kidnapped Ukrainian children, which was mentioned by the ambassador, and another by Katerina Busol on extent of sexual violence by Russian forces in the occupied territories. So that just by way of an update on what we're doing, what I'm trying to do as a scholar who's not an expert on East Central Europe, but has a position where I can try to platform and disseminate the work of scholars who work on that region and from that region on this terrible topic. Now, I've cut my presentation short because the ambassadors were so comprehensive, and there's no point in repeating it. But I hopefully have a few things of interest to say. Now, on April 12th last year, President Biden, the US president, joined the Ukrainian President Zelensky in accusing Russian President Putin of committing genocide in Ukraine. And an increasing number of academics have engaged in a heated debate about the applicability of the concept. In a fateful historical coincidence, Ukraine is a cradle of genocide, as many of us know, and many of us just heard now. Lemkin studied law in Lviv, then in Poland, in the 1920s, and his family was murdered in the Holocaust. He later wrote a text about the genocide famine inflicted on Ukraine by the Soviet authorities in the early 30s, the Holodomor. And he hoped that the new UN Convention on Genocide, passed in 1948, would ensure that such crimes would not recur. But of course, mass violence against civilians has occurred ever since in degenerate forms of warfare that have killed millions of civilians, whether in the US campaigns in Korea and Vietnam in the 50s and 60s, the colonial French war in Algeria in the 50s, the Nigeria Biafra civil war in the late 60s, the Russian destruction of Grozny in Chechnya in the mid-90s, and its backing of the Syrian destruction of rebel-held cities more recently. Genocide has been alleged in many of these cases, but unsuccessfully. Now, I'm not surprised by the inability to successfully apply genocide to these situations. While I agree about prosecuting Putin for the crime of aggression, the problem is not misunderstanding Lemkin and his concept, as many think, but the fatal flaws in the UN Genocide Convention and the character of post-war memory culture. For it was Lemkin who made the Holocaust the archetype of genocide, which he then called the crime of crimes, indeed the most heinous of all crimes, thereby establishing a hierarchy of criminality. With the Holocaust as its archetype, genocide, rather than the Nuremberg triumvirate of crimes against peace, crimes against humanity, and war crimes, became the gold standard of recognition for victim groups since the late 1940s. Contrary to those who think genocide was forgotten until, from then until the two ad hoc criminal tribunals in the 1990s, genocide was alleged consistently in anti-colonial and post-colonial conflicts in the intervening decades, such as the Nigeria-Biafra War, which I mentioned, and also the secession of East Pakistan from Pakistan to form Bangladesh in 1971, if you go back and look at the record. Now, it's no accident that these crises were not recognized as genocide and were quickly forgotten. The states that thrashed out the UN Genocide Convention in 1947 and 1948 designed it so that state sovereignty would not be compromised in waging international and non-international armed conflicts. How did they do this? Well, there are two aspects. One, the UN Convention states that genocide means, quote, the intent to destroy in whole or in part a national, racial, ethnic, or religious group as such, by various means. Now, the as such requires that victims are targeted solely on the grounds of their identity for symbolic rather than material reasons, although I'd say warfare. The states negotiating the convention's definition in 1947 and 1948 deliberately modeled it on the Holocaust, which was understood as history's largest hate crime, to distinguish it from warfare and even from population expulsions. These states, of course, did not regard warfare as illegitimate. They had just defeated the Axis powers. They destroyed their cities with fire and atomic bombs, and they countenanced the forced population expulsion of about 12 million ethnic Germans from East Central Europe. The Cold War was beginning, and independence movements confronted the Western colonial powers who were reasserting control in Asia and Northern Africa, above all the French Empire, but also the British one, the Dutch as well for a while in the East Indies. For the war's victors, the sovereign right of states to engage in international, non-international armed conflict required the rescue of military necessity from its discrediting by the Nazi mode of exterminatory warfare and occupation. Everyone understood that armed conflict affected civilians dramatically. The official committee of experts' commentary on the draft convention, which was written in part by Lemkin, acknowledged that civilian populations were affected by modern warfare with, quote, more or less severe losses, unquote. So it distinguished between armed conflict and genocide by arguing that in the latter, in genocide, quote, one of the belligerents aims at exterminating the population of enemy territory and systematically destroys what are not genuinely military objectives, unquote. Military objectives, by contrast, aim at imposing the victor's will on the loser, whose existence was not imperiled. Killing masses of civilians was acceptable, if regrettable, when motivated by military goals, victory and not destruction. As J.L. Brearley, who was a professor of international law at the University of Edinburgh, observed of the convention in 1949, so very soon after its passing, the intended destruction of the listed groups as such had what he called a limiting effect. The qualification meant excluding, and I quote him, many, probably most, of the most famous massacres and persecutions of history. Because in historical reality, he continued, the perpetrator motives quote, have been more obscure than the Nazis and more mixed. To qualify as genocide, the victim population would need to be targeted, quote, because they were Jews or Slavs or members of some particular group of human beings whose elimination had been resolved on, unquote, and, quote, not enemies in a war or rebels against the government. Accordingly, he continued, putting a whole enemy population, men, women, and children to the sword would not necessarily mean genocide. So the convention, he concluded pessimistically, promised more than it delivered. Nothing important had happened at all, he said, with the passing of the convention. Now, this view has prevailed among the states negotiating the Genocide Convention. And as a consequence, the wars waged ever since, including by permanent members of the UN Security Council, like Russia, now, in which millions of civilians have died, cannot legally be categorized as genocide. Efforts to pin the genocide label on states engaged in destructive armed conflict have largely failed, whether in the US for its war in Vietnam, where it killed millions of civilians with bombing and so forth, or the Nigerian state for its deadly blockade of a secessionist province in a civil war at the time, in which millions starved to death. The second aspect, wars against nationality or national identity are not legally genocide. Russian declarations to destroy Ukrainian statehood and identity, while shocking, are unlikely to count as genocidal intent in a court because they can be paired with other statements by Russian leaders about Russia rescuing Ukrainians from its allegedly criminal fascist leadership. What is more, the convention talks about the destruction of nations, not nationality, and it conceives of nations as biological entities. And the ambassador talked a bit about that as well. As the ambassador reminded us, cultural genocide was removed from the draft convention. The argument that genocide is the destruction of nationality, as opposed to the extended extermination of national groups, reflects Lemkin's original definition of genocide outlined in his book, Axis, Rule and Occupied Europe, about which we just heard. This definition is much broader than the UN one, and that's commonly known, taking an expansive view of destruction and nation at the time. Nations had souls. If you look at how people were writing, you know, the Polish spirit, the Jewish spirit, the Czech spirit, which are, well, at least in Australia, we don't talk like that about nations, but I know it's maybe different in East Central Europe. Anyway, meaning that these souls or spirits could be destroyed by assimilation policies like banning the use of language. After the Nazi invasion of Czechoslovakia and Poland in the late 30s, their governments in exile issued reports on the German occupation, detailing the policies they said were destroying their nations. Ranging from changes in citizenship laws to mass murder, such policies were, quote, part of one long chain of physical and moral violence directed towards the destruction of the Polish nation, as one Polish report put it in 1940. Nationality was under attack, it said. Now, this broad approach, which Lemkin adopted from these Polish government in exile reports, joins the Polish experience of the Nazi occupation, which involved deportations and the destruction of elites and culture under Nazi occupation, with the experience of European Jews who were slated for total physical extermination. I think he wanted what he called a generic notion of genocide, so that the ignored plight of Jews, ignored at the time, mind you, would be noticed by Christian Europe and Christian America, where he was living. He was living in North Carolina. For at the time, if you go back and look at the record, Westerners largely understood the Nazi Empire as an attack on Christian Europe and Christian values, with Jews as sort of part of it, but not the central element. So it's very different from today. So to get the Christians to notice about the destruction of the Jews, he reasoned, it was necessary to unite their experiences. Now, in this book that I've written that was mentioned briefly by Elizabeth, I argue that this was actually quite an incoherent amalgam but it was done for political reasons and quite successful, but has left us a somewhat ambivalent legacy. So anyway, Lemkin argued that in the Hague Convention of 1907, which was the international treaty governing the occupation of conquered territories and populations, that it should be augmented, it should be changed so that, and I quote him, every action infringing upon the life, liberty, health, corporal existence, economic existence, and the honor of the inhabitants when committed because they belong to a national, religious, or racial group. And in the second, every policy aiming at the destruction or aggrandizement of one such group to the prejudice or detriment of another should be criminalized. Now, he sometimes wrote that genocide related to this also meant the crippling of nations. Now, this definition of genocide reflects the lived experience of mixed populations of Ukrainians, Poles, and Jews living serially under Russian, Polish, German, and Soviet rule in the territory of modern Ukraine during the 20th century, enduring multiple phases of genocide and ethnic cleansing since the First World War. It's here, unsurprisingly, that consciousness of nationality and its fragility was and remains intensely experienced. Russia's campaign against Ukraine is precisely, in a way, what Lemkin was trying to capture with his new word. But states did not follow Lemkin's broad definition in the UN Genocide Convention, as we know. Instead, the acts associated with genocide were distributed to other international crimes like war crimes and crimes against humanity. The latter cover Russian conduct in Ukraine. And these I take from the ICC statute: murder, and potentially extermination, forcible transfer, and other inhumane acts. The discriminatory intent based on nationality is captured in the separate crime of persecution. Like genocide, it requires a specific intent as well. The crime of persecution is where we find Lemkin's broader definition. The International Commission of Inquiry on Darfur in 2005, for example, categorized Sudanese crimes in this way instead of using the concept of genocide. From the perspective of the UN and the ICC, these are no lesser crimes than genocide. That's important to emphasize. But international public opinion prioritizes genocide. And that's why some people, like the White House National Security Advisor Jake Sullivan, said that the Russian campaign does not yet rise to the level of genocide. It's this idea of rising. And this means, unfortunately, that conflict-related sexual violence, which has been rampant in the separatist provinces in eastern Ukraine since 2014, is somehow less grave if not perpetrated with the intent to destroy Ukrainians as such. This regrettable blindness to civilian destruction and suffering is one of the problems of genocide I identify in that book. President Biden acknowledged that lawyers will ultimately determine the issue. Whatever the calculations behind his genocide accusation, his government's announcement to provide heavy weapons to Ukraine coincided neatly with this accusation. It was on the same day. Russia's outrageous assault on the Ukrainian nation and people is plain to see. And yet, the UN Genocide Convention signatories define genocide narrowly so that lawyers would find it most difficult to determine that Russia's mode of warfare is genocidal. And while genocide monopolizes people's moral imagination as the crime of crimes, military assaults on civilian populations, whether in the Tigray region of Ethiopia, in South Sudan, where 2/3 of the population require humanitarian assistance, or in Yemen, they continue without really shocking the conscience of mankind quite as much as Russia's war on Ukraine and Ukrainians. Accordingly, my view is that it's time to rethink the obsession with linking that reaction, this being shocked, solely to genocide, and to reimagine a threshold of shocking criminality that does not require analogies with Nazi Germany and the Holocaust. Thank you.
Thank you, Dirk. That was really enlightening. Thank you very much. Let me go to our next speaker, introduce to you Professor Anna Filipa Vrdoljak. Professor Vrdoljak is UNESCO Chair in International and Cultural Heritage at the University of Technology, Sydney. She was Associate Dean of Research there, and she also was a visiting professor at the Lemkin School of Law in Beijing in China. She is president of several societies, including International Cultural Property Society and International Journal of Cultural Property. She has been fellow of many prestigious scholarships. Among them, I should mention Marie Curie Fellow, because Marie Curie Skłodowska was, after all, a famous Polish scientist. And she was a visiting scholar at the Lauterbach Center for International Law, University of Cambridge and New York University. She not only holds a Doctor of Philosophy of Law from the University of Sydney, but she is admitted barrister and solicitor before many courts. Anna, the floor is yours.
Thank you very much, Elizabeth, and thank you to the Jagiellonian Law Society and the Kosciuszko Foundation for your kind invitation to participate in this important and timely event concerning accountability and reparations for atrocities committed on Ukrainian territory since 2013. Ambassador Rapp and honoured fellow panellists and participants, my brief and modest contribution this evening will be in respect of the way that Lemkin understood and defined genocide, particularly the cultural manifestations of the crime, and what does this mean for the role of prevention in the context of the Genocide Convention. It is my contention that they are intrinsically linked. For Lemkin's earliest formulations of genocide, before he conceived of the term and when he was working on its precursor during the interwar period, he had two crimes which occupied him, which he saw as deeply entwined, for they targeted individuals and groups because of their collective identity. So the first was barbarity, and he defined it as whosoever out of hatred towards a racial, religious, or social collectivity, or with a view to the extermination thereof, undertakes a punishable action against the life, bodily integrity and liberty, dignity and economic existence of a person belonging to the collectivity. Whereas vandalism was that whosoever, either out of hatred towards that racial group, religious group, or social collectivity, or with a view to extermination thereof, destroys its cultural or artistic works, will be liable for the crime of vandalism. These twin crimes would be reformulated into one during the 1940s with the drafting of the Genocide Convention. Immediately after Nuremberg and the adoption of the General Assembly resolution on the crime of genocide in 1946, Lemkin wrote, "Well, culture is only as strong and as vital as the spiritual forces which are brought to it by various contributing peoples. If these peoples are annihilated, their cultural heritage is also destroyed. The destruction of a people by genocide results in an immediate and irretrievable loss to all culture." And the preamble to the Rome Statute has a sentiment very close to that. The drafting committee for the convention, of which Lemkin was a member in 1947, included as part of its definition destroying the characteristics of the group, which is what Ambassador Rapp referred to as the cultural elements of it, forced removal of children to another group, forced and systematic exile of individuals representing the culture of the group, prohibition of the use of national language, even in private, systematic destruction of groups in the national language, or prohibition of publication of new ones, and systematic destruction of religious or historic monuments or their diversion into alien uses, destruction and dispersal of documents and objects of historic, artistic or religious value, and of objects used in religious services. We know that Lemkin was unsuccessful in having this definition replicated wholesale into the final text of the Genocide Convention. Instead, the only component that remains in Article 2 is the removal of children to another national group. Despite various opportunities and attempts in the intervening years for the international community through diplomatic conferences, or for the international courts, including the ICTY, through to the International Court of Justice, have resisted the expansion of the definition contained in Article 2. They have repeatedly reaffirmed that these acts may be evidence of specific intent, but they cannot in and of themselves constitute acts of genocide. Ukrainian colleagues in the culture sector and lawyers have worked tirelessly, including one of our panellists, since 2014 to document many acts perpetrated by Russian agents on Ukrainian territory, which go to most of the points on the list enumerated in 1947. We now have reports overnight that the ICC, in its current investigations on the situation in Ukraine since 2013, is considering indictments concerning the removal of Ukrainian children to Russia. The final remnant of what Lemkin had conceived as the cultural manifestation of genocidal acts. I hope that the work done by Ukrainian colleagues on the ground concerning the other examples of the deliberate targeting for destruction or forced assimilation of Ukrainian culture will be used in these prosecutions. This would no doubt reinforce the cases to be made, but also provide a richer and wider picture of genocide that Lemkin was seeking to promote decades ago. To end my intervention, I would like to stress why this broader understanding of what is being perpetrated in Ukraine should be litigated in the prosecutions before the court. The inclusion of cultural elements or components in the definition was resisted by states during the drafting of the convention, for they feared that it was too wide a definition for such a heinous crime. This is what Professor Moses was referring to, and should be reserved for the worst of cases. And of course, many countries were concerned that their own domestic laws and policies would come under the microscope. Lemkin's copious writings made clear that not only was he consumed with the realization and promotion of codification of the crime of genocide, but also to ensure its prevention. He examined example after example drawn from all corners of the globe, endeavouring to better understand the defining characteristics of these programs for the elimination of groups. The inclusion of the cultural elements in his quest was not accidental, but fundamental to ensuring that the international community was alert to the threat of genocide before it came to the end stages. These acts, the cultural elements, served as early warnings drawn from past experience of genocidal programs. We have seen this in our own time in various conflicts on various continents. Should the International Court indictments for the removal of children from Ukraine come to pass and be successfully prosecuted, it reinforces this element of the international community's commitment to the prohibition of genocide. Not only its punishment, but help us work with the renewed dedication to its prevention as well. Thank you.
Thank you, Anna. Thank you for this perspective. It was really fascinating. So let me turn now to Nick Yurlov. He is the senior legal advisor from the Truth Hounds and an assistant professor of international law in the National University in Kyiv. He's speaking to us from Kyiv. And Nick has been involved with supporting legal efforts of Ukraine to resolve the crimes being committed in Ukraine. And he has extensive experience in this area. He is a member of the Ukrainian Bar Association, which is co-sponsoring this event. And his research interests are international humanitarian law and international criminal law. So Nick, the floor is yours. Unmute yourself, please. Yes, thank you.
Thank you. Good evening, dear colleagues. Good evening, dear audience. It has been a pleasure to take part in this interesting conversation. I was initially asked to explain our efforts here on the ground to document war crimes and genocide, which we have seen. But before that, I would like to briefly rebut Professor Moses' statements, with some of which I cannot agree. So Professor Moses did state, most of what he said today, he published on the Lawfare blog, and that post did cause a bit of discussion, but I respectfully disagree with the conclusion that the Genocide Convention as it is today, in its current adopted form, does not apply to the events that have been unfolding in Ukraine for the at least past year. While we understand the limitations of the legal language that the current version of the convention has, we nevertheless are confident in that it is the precisely destruction in whole or in part of a national group which is going on in Ukraine right now. And if we actually try to define the term national group, we could refer to the jurisprudence of the International Criminal Tribunal for Rwanda in the Prosecutor versus Akayasu judgment, where the tribunal defined the national group as a collection of people who are perceived to share a legal bond based in common citizenship, coupled with reciprocity of rights and duties. At the same time, a nation is considered to be more than just a group of people that hold the same formal nationality. It is rather a collection of people with a common wish to live together, which have a common ideal or a common goal, common aspirations. And that these are the words of the special rapporteur, Mr. Dudu Thiam. So while it is indeed hard to compare the concept of genocide as we saw it in the Holocaust case to the Ukrainian Holocaust, I think it is important to understand some of the cultural origins of the whole Russian-Ukraine war. And I will start my presentation with exactly that. The cultural origins of the Russian invasion of Ukraine and the Russian attack on an attempt to erase Ukrainians as a separate nation stems back through Russian culture, which I have had the experience to see firsthand as having been born in Sevastopol, a predominantly pro-Russian city, and having attended a gymnasium named after Alexander Pushkin. And since childhood, and this is something that I saw from my personal experience, and which is I now see confirmed through my overall interactions, since childhood, Russians are taught that Ukrainians are the same people as Russians, один народ, and whoever wants to disagree with that is considered a Nazist or Nazi or Banderovец as the new term for it. Ukrainian culture has been denied repeatedly over many years, over actually many centuries, as Ukrainian language has been banned back in the Russian Empire and then significantly restricted during the Soviet Union times. So one of the best analysis in terms of the cultural dynamics between Russian and Ukrainian histories and cultures are explained in this great analysis by Kamil Galeev, which I do recommend to you to read. His conclusion is that the war happened because Russia never accepted existence of Ukraine in the first place, and Russia not just an entity as a state, but the whole people of Russia, because this has been a part of an integral part of the culture, which has been repeated through many iterations. The core argument is that Ukraine is a fake nation, which has been created artificially by the Austrian General Staff or by Lenin. They actually cannot make up their mind. They claim both arguments. He particularly refers to his analysis, which, and this is why I bring it up, to the poem by one of the prominent Russian poets, Brodsky, called On the Independence of Ukraine, the final verses of which are, when you're dying and scratching your deathbed, you'll be wheezing Alexander's, meaning Pushkin, lines, and not the Taras's lies, meaning Taras Shevchenko. Brodsky here refers to the two icons of Russian and Ukrainian culture respectfully, and he particularly attacks this core figure of the Ukrainian culture by saying that it is inferior to the Russian culture. Therefore, Kamil Galeev concludes that cultural uniformity is the real goal of the Z war, and the problem with Ukraine, as is embedded deeply in the Russian understanding of Ukrainian, of the whole concept of Ukrainian nation, is that it exists, while Ukraine, according to Russians, should not exist. And that's why the war was started, to erase Ukrainians from existence and to kill whoever does not agree to be called himself a Russian. Now, if we look at the actual definition, the term genocide, we are having all these forms, evidence from the facts on the ground. We have willfully committed acts for the purpose of total or partial destruction of a national group of Ukrainians, which is conducted by extermination of members of the group, inflicting bodily injuries, creating of life conditions, which are in the total of partial physical destruction, efforts aimed at decrease or prevention of childbearing, and of course the forcible transfer of children. Now, there have been a lot of reports which directly describe all the factual details and link them to each of the elements required by the convention, including explaining the mens rea and the specific intent. Given the limited time we have, I will not, of course, go into details on each one, but I will briefly refer. So what we started with back in April 2022 is there was a global call for action to prevent further genocide of Ukrainians by a group of Ukrainian lawyers. It has been signed by more than 2,000 people all over the world. And the core idea of this document is that even if there is no sufficient evidence at that moment, and that was just April when the Bucha massacre evidence was surfaced, the contracting parties to the Convention on the Prevention of Genocide have an obligation to prevent further genocide. And we outlined particular steps that could be done to prevent the further genocide of Ukrainians. Then, just the following month, the New Lines Institute published an independent legal analysis of the Russian Federation breaches of the Genocide Convention. Now, once again, I won't go into reciting its main arguments. I would like just to invite the audience to analyze and read this report, because we won't have the time to debate each and single element here. And there is another article which will be published soon, and there is a there is a version of it printed. There's a preprint available already by my colleagues from Truth Hounds, as well as his colleagues from National University of Kyiv Mykola Academy, about the legal reasoning and historical context of the genocide committed by the Russian Federation in Ukraine. So in that regard, I kindly disagree with the conclusion that the acts that are being committed right now showed full of the definition of genocide. Now, if there are no questions related to that regard, I will move to the initial part of my presentation, where, as I was asked to explain the efforts that are being made to document and collect all the necessary evidence and prosecute the perpetrators of war crimes and genocide. And some of the issues for discussion, which we see here and we observed not just over this year, but since the start of the war back in 2014. So this presentation has been initially prepared by my colleagues, Dmitro Koval and Katerina Busol, and I just added some parts of it in respect to genocide, but they have already covered the ongoing problems that we have in terms of documenting of war-related crimes in Ukraine. Now, first question, and while it may be of procedural nature, but it's nevertheless important, is competing jurisdictions. Then I'll briefly cover the opportunities and challenges we have for documentation of conflict of war-related crimes, and then briefly address the prospects for domestic prosecution of such crimes. For competing jurisdictions, as you well know, Ukraine has accepted the jurisdiction of the International Criminal Court in its two declarations of February 2014 and April 2014, while having signed but not ratified the Rome Statute of the ICC. We still have its jurisdiction of all events which happened since 2014. And we know that ICC is now actively moving into the direction of opening the first cases. In parallel to the International Criminal Court, there is a plethora of human rights organizations and donors which, for obvious reasons, have increased attention to the situation in Ukraine. And in parallel with the with the classic organizations which have been working in the field for a long time, we witnessed the birth of specialized organizations which are specifically focused on documentation of international crimes and creation of evidence gathering or documentation units in other organizations. Moreover, talking of national law enforcement, we saw the creation of particular war crimes unit within the Prosecutor General's office and a particular war crimes units in the National Police and the Security Service of Ukraine. Of course, the law enforcement system was not prepared to deal with war crimes of such scale and gravity before, but what we witness right now is the increased capacity of Ukrainian prosecutors and law enforcement bodies generally to investigate war crimes and apply sometimes very challenging and controversial standards of international humanitarian law and international criminal law. So in terms of national prosecution, the Criminal Code of Ukraine criminalizes genocide. And the definition of the act of genocide is quite similar to the definition from the convention. And we know that there are ongoing cases right now, and we know that there have been strategies developed to particularly prosecute the crime of genocide in Ukraine, because it is very important that not only the international tribunals or courts deal with the matter, but particular national law enforcement agencies which have direct access to the evidence on the ground and have greater capabilities to work with the evidence. Apart from that, a very common violation which we have is the violations of the rules of customs of warfare, which even though Ukraine has not ratified Rome Statute, we do have the criminal prohibition for war crimes in Ukrainian criminal code. And documentation happens through the following key actors. So we have the Prosecutor General's office, which is one of the central institutions aimed at prosecuting genocide and war crimes, and which works jointly with mobile justice units within the Atrocity Crimes Advisory Group. And on the other level, we have National Police and Security Service of Ukraine, whose investigators are directly conducting criminal proceedings, while the prosecutors oversee them. The prosecutor's office reports that there have been 73,996 cases documented which are connected to war crimes and the crime of aggression and propaganda of war. Of them, 71,747 cases are investigated under Article 438, in particular war crimes. A separate element of that, and a moment of great attention, is the crimes against children. So what has been documented as of today, and this is only the portion that has been documented by now, given the evidence that is available today, while not all of the territory of Ukraine has been liberated, is that we have 464 children dead, 935 wounded, 373 missing, and at least 16,226 children confirmed as deported forcibly to the Russian Federation. Now, I will once again remind you that deportation of children is one of the elements of the crime of genocide, which is sufficient per se. Now, at the same time, some of the Russian sources claim that as much as 744,000 children have moved to Russia. This claim is impossible to verify at the moment, but we nevertheless record this statement that they claim that 744,000 children have been relocated, as they claim, from or have escaped Ukraine into the territory of the Russian Federation. As to other key actors that are present in the field of war crimes and genocide documentation, is that since 2014, when the war began, large Ukrainian non-governmental organizations have been established to deal with a wide range of human rights violations. And those organizations have now expanded their work to include war-related crimes. So there are human rights organizations which have introduced war crimes, additional capabilities, and then there are non-governmental organizations which are focusing specifically on documentation of war-related crimes, such as the Truth Hounds, which I'm honored to represent here. There in a separate category are regional Ukrainian non-governmental organizations, such as the Crimean Human Rights Group, Regional Center for Human Rights, or Vostok SOS, which deal mostly with the particular geographical areas. And then there are Ukrainian NGOs that are documenting conflict-related crimes in particular thematic areas, such as sexual violence or crimes against children, as well as the final point. So as you see that the scene here is quite diverse. Of course, the international non-governmental organizations that have been working consistently in Ukraine since 2014, such as the Human Rights Watch. Now, given the vast amount of these organizations, it was very important to coordinate the efforts, and at least two major coalitions have been established, one being called the 5 a.m. Coalition, which refers to the moment that the full-scale invasion started about 5 a.m. in the morning, and the Tribunal for Putin Coalition. As you see, those coalitions include a wide range of Ukrainian and international non-governmental organizations. And this type of coordination is very important to avoid duplication of efforts. So these are the participants of the 5 a.m. Coalition, and these are the participants of the Tribunal for Putin initiative, being the three major ones and additional 24 organizations which have joined it. The key challenges we face when documenting genocide and war crimes is the first problem, which might not seem obvious at the first time, being over-documentation. When the very same incident is being documented by multiple organizations, including nationals, international, and the government organization, there is a risk that evidence may not be collected properly. And the challenge that we face is that there is no one overarching evidence storage and analysis database. So not only our efforts may be duplicated when a particularly blatant war crime happens, but it's also hard to understand who is working on who specifically and who has documented what and what are the conclusions and what is the evidence that has been collected. So the other challenge that comes to it is the potential lack of credibility due to lack of objectivity. And there have been voices already that Ukrainians, NGOs, which are documented, cannot be objective because, well, they are Ukrainians, and therefore they have a bias to call every act that has been committed a war crime. This is a problem which can be overcome by collection of evidence in a proper manner and providing correct legal analysis. So I would say that while this is one of the challenges, it is not something that bars us completely from doing our work. And among other challenges, we see that sometimes there may be political considerations which come into play, which affect the work of some of the units. While this challenge is on the table, we don't see it at the moment as significantly affecting the efforts. And we are working, including with our international partners, to have an honest side review or peer review of the work we are doing, to make sure that we are objective in our analysis and in the activity and in our evaluations. So overall, we can say that there is a greater interest and a greater need in expertise for war-related crimes across the whole country. And the work that has been ongoing so far is quite significant, because the overall competence of state authorities and non-governmental organizations working in the field has risen significantly. And there is a lot of effort, both national and international, to share this knowledge, share this better understanding of international criminal, international humanitarian law, which directly gives particular results. Now, the final issue, which also has to be taken into account, is that one of the core principles of humanitarian activity, do no harm. It is very important for war crimes documentators to avoid re-traumatization of the victims of these war crimes. This is why many organizations have specifically embedded psychological experts and which provide guidance on how to best work with the victims to avoid such re-traumatization. That is it in terms of what we see here. So these are the challenges that we face. Of course, there's also problems with imperfect criminal legislation on international humanitarian criminal law. And there are ongoing efforts to improve the legislation, to fine-tune, because, for example, Article 438 of the Criminal Code is of a blanket nature. It sends any other violations of the rules and customs of the rules of war, which have been which are described in the international conventions ratified by Ukraine. And of course, the major challenge is the lack of alternative forms of distress. So the work we're doing right now is very much work for the future, that we hope that we will able to bring the perpetrators to justice. And for that goal to be possible, it is very important that all evidence is collected today. It is preserved in the most accurate way as possible. That is it from my side. Thank you.
Thank you, Nick. This is really very comprehensive and allows us to understand what is happening in Ukraine and what guys you're doing. It's really commendable. So thank you so much. And now allow me to introduce our last speaker, Prosecutor Thomas Hannis, who is a very distinguished, experienced prosecutor, with over 40 years of experience and in general as prosecutor and 20 years on international level, and who was a lead prosecutor in a 2-year-long crime trial of Kosovo 6 and many other Yugoslavia-related crimes. So, Tom, I will not elaborate anymore. Your vita and every other speaker's vita will be posted on our website, so please take it away.
Thank you. It's an honor to be here. I appreciate the opportunity. I'll try to keep this short. I want to talk about my experience working at the International Criminal Tribunal for Yugoslavia from the years 2001 to 2012. And I think this is of interest and use to those people who will be working on the investigation of crimes by the Russians in the Ukraine. Based on my experience at the ICTY, I can point out some of the difficulties and maybe ways to avoid some of those processes. First of all, you have to decide who you're hoping to prosecute. And I think regarding the Ukraine, there's some good ideas about people that you want to prosecute, including people at the highest levels. And doing cases of that volume and that size and that complexity take a lot of time to prepare and get ready. And you will need insider witnesses to have a successful prosecution of cases like that. And there are difficulties with cooperating insider witnesses. They're running a great risk, even at possibly losing their own lives by cooperating with the prosecution. And some people who probably deserve to be prosecuted more than serve as a witness for the prosecution end up acting as witnesses because the prosecution is under a lot of pressure to get their case started and start the trial as soon as possible. I also want to talk about the importance of selecting the right interpreter, because you will need, at least if you're an English prosecutor and you're going to be doing a case about Russians in Ukraine, you'll need interpreters to help you interview witnesses. And it's important to have the right interpreter. I'll tell more about that in a minute. And then plea bargaining. Coming from the United States, I think in state courts and the federal courts, the percentage of cases that are resolved by plea bargaining ran somewhere around 95%, just because we have too many cases and we don't have the time and resources to pursue cases with full trials. Let me see, okay. So deciding who to prosecute. It depends on the number of crimes you have and the resources you have to do those investigations. Identifying the crimes committed and the people to be prosecuted is what you have to decide upon before you get started, so you know how many resources you need and how long it maybe is going to take. You're going to have to establish command responsibility to pursue prosecutions of the highest ranking individuals involved in these crimes, and building your case from the ground up. You got to start down at the lower level and work your way up. I can tell you at the ICTY, which was founded in May of 1993, they did not get stuff together enough to have their first trial until May of 1996. And that was against an individual named Duško Tadić, who was basically a paramilitary, low-level guard at a prison camp called Omarska. Out of the some 200 people prosecuted later on, that was one of the lowest levels possible, but there was a lot of pressure in the ICTY to get started. So that's something you'll have to think about when you're starting with a new tribunal to do war crimes or genocide crimes. Difficulties with working or cooperating with insider witnesses. It's almost always necessary to have insider witnesses in doing some cases like this that involve such large organizations and such complexity. The key to identifying the internal structure of the army or the police or the political party, the leaders and those most responsible and culpable for the crimes. Some might try to save themselves by volunteering to assist. The prosecution. And how to decide whom you can trust to work with you as a prosecutor is something that involves a lot of care. The picture on my slide here is a man named Micho Davidovich. He was a cooperator for us at the ICTY. He had done solid investigations in the field. His information we were able to confirm from other sources and documents. And his interview, her first interviews before we went to trial were very helpful in our entire case. And related to that is the other point I wanted to make about the importance of selecting the right interpreter. In doing these cases, if you're a prosecutor from another country and you have witnesses speaking foreign language for you and for the judges, some of the judges, it's really crucial to have the right interpreters from the beginning all the way through the trial, especially when you're dealing with insider witnesses. Whether the language is Ukrainian versus Russian or Bosnian, Croatian, Serbian, you need somebody who knows about the background of the case and somebody that witnesses can feel comfortable with, but also you as the prosecutor have to feel comfortable that the interpreter is making it clear what you are doing as a prosecutor, what you need to have from the witness, etc. And I had some experiences in my life as a prosecutor in the federal government back in Arizona, where sometimes we needed witnesses for Mexican witnesses or people from the Indian reservations on which we prosecuted crimes. And it's vastly important to understand. Our insider witness was the highest ranking uniformed policeman in Yugoslavia at the time. And it was a very dangerous thing for him to do, to cooperate with us at the tribunal. And during our first interview, after the first hour, when he left the room for a break, the interpreter told us he was testing us, me and the investigator, to see if we really knew what we were doing, if we really knew what had happened in the years during the war that we were investigating and who was who. And so when he came back, we asked him a question about an important regional meeting of police in Bosnia shortly before the war started. And he said, oh, yes, I was at that meeting. Who was the local commander, the regional commander there and did the speech? we knew who it was. We said, Duško Savić. And he then felt like, oh, okay, these guys know what they're talking about. And he became helpful and ended up testifying in 5 or 6 trials there. So that was important. The final point I wanted to talk about was plea bargaining. Coming from the US, as I said, we had something like 98% of criminal cases get resolved by plea bargains. And at the ICTY, we actually, in the early days, maybe had something like, I think it was, 19 cases resolved by guilty pleas. But it happened early on, and after that, we weren't able to do it anymore. Partly because many of the international judges came from countries where they didn't have that as a process, they didn't like it. And defense attorneys and the clients were, after the first few guilty pleas, decided that this wasn't really working well. Because unlike in America, where you could work out a specific deal and say, okay, he's going to plead guilty to count 1, he'll get 6 weeks and 3 days in jail, he'll pay a $27 fine, and I'll have 60 hours of community service. And the judge will either accept that or not, but everyone knows what it's going to get. At the ICTY, the judges would not agree to anything like that. All we could do was make a recommendation on behalf of the prosecution. For example, to say the defendant will not get more than 12 years in prison. But it can only be a recommendation. And early on, we had some cases where the judge, after the accused who had pled guilty, he testified against some other soldiers or policemen from his country. And then when it was time to be sentenced, the judge would decide whether or not to give him 16 years or less. But in a couple of cases, the judge ignored our recommendation, and because he thought the witness had lied during his testimony, and he gave him 25 years instead of 16. So that didn't work much after that. But I still think, depending on the circumstances, plea bargaining may be something useful and maybe something that you want to consider. I'm sorry, that's all I had for now. I appreciate the opportunity, and thank you very much.
Thank you, Tom. And thank you everybody for being here. I apologize to our audience. We're running a little bit over time, but this happens, especially when you have so many amazing speakers with such insightful knowledge. We have many questions, and because we are at 2 hours, 19 minutes, I think I hold them for now. But let me say 2 things. First of all, let me thank everybody who participated in making this webinar possible, starting with Jagiellonian Law Society and Kosciuszko Foundation, various committees of American Bar Association and Fellows of ABA, Warsaw and Kraków Bars, Polish Cultural Institute, New York, New Jersey State Bar, Ukrainian Bar Association, New York State Bar Association, and especially the Ukrainian Task Force, University of Pennsylvania Department of Russian and East European Studies, University College London, University of Aberdeen, Jagiellonian and Warsaw University, Seton Hall Law School and Seton Hall School of Diplomacy, American University Law School, Temple Law School's International Law Society, Center for American Studies and University of Poznań, and last but not least, a very, very special personal thank you to 2 amazing women, 2 amazing judges, Honorable Lisa Ridgway and Honorable Linda Murnay. Thank you again to our amazing speakers for your knowledge. And thank you, Ambassador, for your keynote speech. This webinar, the related materials, the recording, the vitas of our speakers and their publications, so you can read them, will be posted on the Jagiellonian website and Kosciuszko Foundation website. Those of you who want CLE credit, I got several questions. Please write to the Jagiellonian Law Society @gmail.com. We will send you the forms and you'll get the credits. And thank you all for being here, especially the speakers, for your work, your preparation, your knowledge, and your expertise. Thank you, audience, for being here. And let me leave you with 2 quotes. one from my favorite fellow anthropologist, Margaret Mead, and another one from President Kennedy. And the quote from Margaret Mead is beautiful. She says, "Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has." And President Kennedy said, "One person can make a difference, and everyone should try." Thank you. Thank you for being here. Thank you all, and have a lovely day.
Thank you very much, Elizabeth, also for you.
Oh, thank you, Agnieszka.
Thank you very much and goodbye.
Thank you, goodbye.